Dear friends and family, hello, pranam. Following is the conversation with Mr. Mrigank Mauli. He is a senior advocate at Patna High Court. I have first heard him arguing before Patna High Court during my judicial clerkship. In this conversation, we talk about his journey, how he has first joined army, then quit that to prepare for civil services, and then finally ended up practicing law. This conversation is full with his insights from all his experiences, and we also talk about some of his cases. Hope you enjoyed this conversation. Welcome to the podcast, sir.
Thank you.
I've heard you arguing before the Chief's Court during my judicial clerkship, so I'm aware of your arguments. What I've also heard about you from court staffs is that you have trained and mentored lot of juniors from your chamber has been doing really well for themselves. So I've been thinking about doing this, talking to you, not precisely doing this podcast, but I've always wanted to come and talk to you. But I'm so glad that this is the medium through which we are going to have exchange of ideas, exchange of discussion. So thank you for agreeing to do this.
Welcome.
So we'll talk about your cases. We'll talk about some of the cases that you've been part of, some of the cases that I've seen you argue. But before that, I would like to start from your background. Basically, where were you born? Where did you do your schooling from and all of that? So we'll start from there.
So basically, I was born here in Patna only, but never studied in Patna except for my plus two. So I was a complete stranger to this place. Patna was though my place of birth, but it was a complete stranger to me when I actually came here to practice law. So and that was the most surprising part because my parents have all through lived here and I never lived here.
So until your standard 12th, you were here.
No. All through except for plus two.
Okay, except for plus two. So for your
Yes.
plus two, you were here.
Except for plus two, I've always studied outside for one school or the other. I was in Pilani, Birla Public School, Pilani, and so I. Before that, I did my primaries from Princess College, Raipur, or otherwise people call it as Rajkumar College, Raipur. It's officially it's known as Rajkumar College, Raipur. Otherwise, it's known as Princess College. Once erstwhile princes used to study there, and then we joined there and studied for first and second, and then we moved on to Pilani, and from Pilani we came back. Me and my brother. When I say we, I mean me and my brother. Two of them came back to this place and joined St. Michael's for plus two.
Okay.
And then thereafter, I couldn't get admission in Delhi University because of the age bar. So even when I had more marks than my brother, I couldn't get through into the Delhi University and call it fate.
Delhi University for your graduation.
For graduation. So I fell short of. They have some rules with regard to age that you can't take admission beyond a certain threshold. If your age is about 15 and a half or 16, you can't take admission there. So I fell short by about 6 months. Even after giving a relaxation of 6 months, I fell short by. So the fate took me to Chandigarh.
Okay.
So I was very fortunate to study in Chandigarh, and then there was this background. There was something in my mind playing somewhere unconsciously, which took me to, and considering the environment in Chandigarh and the Punjabi friends, and that took me to army. And then, no, before that, I got an admission in JNU. So I was so much wanted to study in JNU and ancient India from Romila Thapar. I always wanted to study that, but my father insisted that you would be wasting about a year's time. So you should. But as the fate would have it, I was destined to be there in Chandigarh only. So what they do is that I did my graduation in 2 years. Unlike everybody doing it in 3 years, I did my graduation in 2 years. So one has to do one bridge course. So when I was in MA first year, then I made an application for getting an admission in JNU and made it to ancient Indian history.
Great.
And so I wanted to study, but then my father insisted, no, you have to continue here because you'll be wasting 1 year's time. But then, as the fate would have it, I didn't complete my MA also. So, and from there, I joined army. And then after army...
So army you joined after your graduation? Or after
Yes.
your intermediate? After your
No,
graduation?
after graduation.
After graduation. So that'll be CDS, no?
And that was CDS. So I went to IMA and IMA, and then at some point of time, certain medical issues had cropped up, and so they boarded me out. So once they boarded me out, I was again back to after almost what...
During the last war
3 to 4,
which
5.
India had during 71, you must be in your school.
71. 71, probably I was just playing around in half pant. I had not even joined a school, I suppose.
You haven't joined.
Yes, I had not even joined the school. So I don't think so.
But
that
did
was
that
not
play
the-
any role for you to
No,
join?
but that had some. I mean, that had some influence because our house was there in 3 Hardinge Road, and so right behind our house, we used to play around, and right behind the house was this railway line, and then these people would.
The army battalion.
There was this army people going, and then there was movement of trucks and vehicles loaded on the train. So we would, because that train would occasionally stop behind our house, and we would go to them, we'll wave to them, they will wave back to us, and then something was there in that entire episode that stuck in my mind, maybe unconsciously, and then I was very enamored with
defense forces.
yeah, defense personnel. So I thought I will be there in army, and that insisted, and then I went in spite of opposition from my father. So he didn't want me to go to army.
But the training stayed with you. You are still keeping yourself fit and everything.
Probably no. I was always very conscious about health, but even
before you joined
before I had joined, I was into all kinds of sports, or into all kinds of... In school, I was in almost all the school teams, including basketball, football, hockey. Every school team, I was there. Volleyball. So I was into every school team.
Okay, so you joined IMA, Armed Forces. How long did you work there for the army?
I was there for about, means if you include the training part of it, so I was there for about 5 years.
5 years. So after being commissioned,
that was about 3.5 years.
3.5 years. Then for some medical reasons, you had to leave.
They boarded me out basically because they downgrade you from A category A to category D, and then they board you out. So if you go to category D, then you are not fit to continue in the army. So you are boarded out. So I was boarded out. Then I had to again start studying after 5 years. So it was a big ask. Because I had not studied anything in last 5 years, especially these kinds of subjects like history, law, and all. So I had to come back, and I had to decide that if I want to. My father was very enamored with civil services. So he always wanted that somebody should, because he was himself an IS, so he always wanted that somebody should get into. My brother had not even given one paper of civil services, so he was like, I was like his that dark horse. He wanted me to run that race course. So I came back to continue with the legacy, and I came back and I took law as my second subject. I had this issue that what should I take it, because history was one of my subjects in graduation. So That was my obvious choice, and I used to love history, especially the ancient Indian history. And I was very fascinated with it. Probably if I would not have joined anything else, probably I would have gone in and would have become a professor in
teaching
ancient
history.
India. And there are things that don't means come to you in spite of all your desires. One was studying with Romila Thapar, and I was so close to it, and yet so far. So, well, anybody who studies ancient India, he wants to be a student of Romila Thapar. So that was my generation. I don't know about the present generation. That was my generation. If you love ancient India, you have to be with Romila Thapar. That was a privilege for everybody. And came back, picked up that subject. One of the subjects was law. And then the moment I came back, I joined law, Delhi University,
CLC,
law faculty, CLC, yes, CLC. And then the very next year, I took up civil services.
So you enrolled yourself in
the moment I enrolled myself, I also started off with my civil services exams also, because I had limited number of chances. So
and you were doing by yourself or some coaching or something?
No, nothing.
Was there any coaching at that point of time?
I had no friends, so I didn't know anybody to guide me to any of the coaching institute. I had just come out and I had to start off with my civil services.
So was there any coaching institution like today we have so much coaching institution?
Then also they were there. The famous ones were Rao's, and I was fortunate enough in the sense that my brother never intended to do civil services, but yet he collected all the notes.
So the notes were passed on to you.
He had collected all the photocopies of all the history notes from every place that was possible. So he brought in all the notes, and I went through all those notes. And then I was into studying books only. I hardly referred to notes. I concentrated on reading books only. And I bought books, history books, medieval, ancient and Indian, modern Indian history. So I concentrated studying history from the books. But then interesting part was everybody discouraged me from taking up law. So as a subject for civil services.
Why so?
Everybody said that you don't get marks in law, and then
too verbose. You have to write so much.
Not even that, but the syllabus was so extensive. Means it covered almost every aspect of law. Means right from international law, administrative and labor law, income tax, everything was covered. So you had to be very selective about what to study, what not to study. And then since I had no friends to guide me, and I never had any company, so I was a loner basically. I was studying on my own, preparing on my own based on whatever notes I had.
But you still chose law as an option.
I still chose law because I had no other option, because I didn't want to start off with any other subject.
Because you were studying law.
Because I had enrolled myself in law, so I thought that might as well take it up.
Right.
Not as something that I would actually be able to make it, because for me it was very difficult to starting off with the education part. Once again, after 5 years from scratch, you start off. I was not even in the frame of a student.
Right. It must be
so
hard.
The moment I came back, I had to start it off. So a student, there is a continuity, graduation, post-graduation, and then it goes on. For me, it wasn't like that. I had to come out, and then suddenly I was faced with choices, and very little choices, because my age was running out also. So I had I was commissioned at the age of 19 and a half, and then I was back at the age of 23. So then the attempts that were allowed was about 4 attempts, and I had just about 3 more attempts to give. And then we always fell short of attendance. And we were not given those admit cards. And so because I was studying law for my civil services, and I was preparing for civil service, I would hardly attend classes. So the law that I now know of is something that I have read on my own. is not something what the teachers ever taught me
Because
in
you
the
never
class.
attended any
Because I hardly attended. It is not that I never attended,
hardly
but I hardly attended. So I had shown you those books and all,
Right,
where I had very copious notes and all, and people would tell me that civil services, if you are going in for civil service, then you will have to be abreast with all the latest. So you would have found that all those cuttings,
newspaper
cuttings, yes.
Studying from Aarti
Yes,
Sharma's
yes.
book, we have all the underlined and
MP
everything.
Singh's and books and all, Constitution, at least I have read on my own. Nobody ever taught me Constitution.
Both for your law school as well as for your civil.
Yes. Whatever I read for civil services was what that I reproduced for. I never got marks. So, but when I gave civil services, and the kind of marks that I got was astronomical. Means people would not believe, because people would tell me that you will have to write citations and names and citations.
Then only you'll get marks.
Then only you will get marks. So I was very bad in remembering numbers. So it was like that only. But then when I first attempt, when I gave it, then I got 349 marks. And people will not believe that somebody could get that kind of marks. People have got higher than that. But somebody who was just in first term or second term, that he would get 349 marks was something that was definitely was not in people's imagination, that somebody would. And then
that too with law as an option.
With law as an option, and history was again an extensive subject. 349, and then the next time that I gave was about 300 and 54 or something less than that, probably 49, somewhere around 345 and more than 340. So, but in law, when exams of the Delhi University, I would never get marks. I would continue to get marks here in civil services, when people always told me that it is very difficult to fetch marks.
And what is easy was difficult.
Yes, what is easy. And I couldn't make it through in 3 years also. And I continued to fail in jurisprudence 1 and family law.
So you did your 3 years law in what?
In 5 years. Probably I was the first student for 5 years.
So you set the precedent for 5 years law.
Probably they changed the entire syllabus just because somebody did well in civil service.
They must have realized that for 3 years it's very difficult to accommodate. So let's accommodate candidate in 5 years.
For Delhi University, I must have been the unique candidate, because I was the first candidate or a student who did law in 5 years. So. And that too in the very last attempt. Probably I would not have made it to becoming a lawyer also if I would not have passed the exam jurisprudence once in the last attempt. So they said that if you don't pass now, and it was a desperate situation, because I couldn't make it to the civil services, though I made it to the interview twice.
Share some incidents from the interview, no?
There was the most interesting part. The second time that I was in the second time when first time when I got to the interview. So I was in the interview board. They asked me all kinds of questions about my backgrounds, army and all, everything. That apart, the most interesting that I still remember is that they asked me they said that what happens, what kind of an offense does it make if you're moving on a platform and somebody slaps you. See, I take you, what offense? Because we were just in second term or third term. First, second, probably second term or third term. And we had been studying the bigger offenses like murder and all this. I know, extortion and culpable homicide. I never thought that somebody would ask me such a simple question. So I had to tell him, yes, sir, we have still not been taught all these offenses. So we are only in the third term, and that I don't know. And then the most interesting was in the third term and in the third attempt, when I got to the interview, something very interesting happened, that on the very day I had to go for the interview board, there was a newspaper item in the Economic Times, and I was in a hurry on that day, and so I missed out on the Economic Times, and they had comparative study of the administrative law vis-a-vis the administrative law of India, and the origination of administrative law and where it all originated from, the administrative law concept. And then I went to the board, and then they asked me that question. I had no idea. I had no idea. I told them I have no idea. But when I came back, and I was just flipping through that newspaper, and then I realized that they were asking it from that newspaper,
Which you have already read.
the same day's newspaper. And had it been a situation where I would have gone through that newspaper, probably that would have fetched me more marks. But then it wasn't a very bad mark. Then they gave me a 158 out of 300. It was a fair marks. But that was the attempt when the law marks came down and the history marks went up. So I mean, I still had about 55% of marks, but by then the cutoff had gone up very high because the seats had come down the moment I had joined. 94 Indira Sahani case, and then it was 50% reservation, and then and there was a reduction in the number of seats also. So it had come down to almost 200 and odd seats for general unreserved category. So, and the destiny had to bring me to this place. And then my father died, and then while he was still in service, he died, and then we had to leave Delhi. We came back. I didn't had to come back. I didn't have to come back, means because I had decided to stay on in Delhi, but somehow the destiny had to bring it back, bring me back to this place, because my mother developed those kidney failure issues, and then I shifted.
So
and I was a complete stranger to this place.
It was completely accidental for you coming back to this place.
Because nobody else could have moved here, because my sister was married, my brother was already working. They couldn't have moved, and and I was just getting initiated into this profession, and I had still not passed the exam.
Right.
So I was the most flexible of all the three. So I came here.
This was 97.
This was 97, and 97 I had not still cleared my law exam.
Law exams.
So it was only 98 that I had cleared my law exam. And then I came to this High Court and started working. And then at that point of time, there was this pass system. So every day I would go to the court and get a pass made. And then I had gone around getting in touch with lawyers with whom I am supposed to join. But then I met quite a few lawyers through one or two people whom I knew here. That was the only number of people that I knew, two of them in Patna. And they took me around. One was my cousin. He was working in sales tax here. And he still continues to be. He'll be retiring this year. But he took me around to people, and then somehow through a contact in Delhi that I met Mr. Pawan Kumar. With his reference that I got an entry into his office, and then I continued with his office. But then initially they would tell me ki bhai pass banao. If every time that you want to go into some court, pass banao. So it was a tedious job. So one of my friends told me ki lal tie pehen lo. So at that particular point of time, they had started off with this apprenticeship, because you have one year full. You will have to do apprenticeship, and during that apprenticeship, you were supposed to put on a red tie.
Red tie.
So you were somebody who were identifiable in the court.
Even from far.
Very far. And you were not allowed to sit anywhere. You never had that priority or that privilege of sitting anywhere. The moment
you were given access to the courts.
You could get into the court, but you can't sit.
Right.
Because the moment you would think of sitting, there will be somebody with gown, and they would tell you to get up.
Right, but with the red tie, you don't have to make passes.
Then
at least that privilege was there.
That privilege.
Right.
till the time that I actually enrolled myself. And that was in October 1998 that I enrolled myself, and I continued to do that apprenticeship till about January 2000, 1999, when they decided to, the Supreme Court decided to quash that notification of the Bar Council of India. And then we were given time sometime in the month of May 1999, and we were asked to get ourselves enrolled with the Bar Council as lawyers. And then we became lawyers.
And until this point of time, you cleared your exams as well.
1998, I had cleared the exam. That was the last attempt that I had. And that was a desperate moment for me, in the sense that if I would not have cleared that exam, probably I don't know what I would have been doing.
But you cleared your exams, enrolled yourself in
yes.
Patna High Court, started your practice.
Yes. And then interesting part is I just got exactly 50% marks. But any marks less than that number would have made me a third divisioner. Otherwise, I was a second divisioner with 50%. So I always tell people, if you want to practice, marks don't matter. See, marks and education doesn't matter. You want to do LLM, you want to do PhD, you do whatever that. For practice, a basic degree is good enough.
And long rail. Then you have to run the marathon.
Yes, you'll have to run the marathon. Marks doesn't matter at all. However good school that you come from, it doesn't matter much.
But your professional journey must have been very hard for you. Like joining army, quitting army, preparing for civil services, not getting into it. Starting your practice, and I think you quit Patna High Court also to join somewhere else. You told me last. What is the story there? So you started your practice here?
98 that I started out. 97 I had joined Pawan Kumar. Otherwise he was known as Pawan Kumar Rajgadia. Means his official name was Pawan Kumar. His father was Badri Prasad Rajgadia. He was a renowned taxation lawyer, and his son and he had risen to great heights. At the age of 45, he was one of the leading lawyers, commercial side, especially electricity and sales tax. So 97 I joined. 98, 99, unfortunately he died. So we tried to run his office, the juniors as such. 99 Diwali. On that Diwali day that he died, he fell in the bathroom and died somehow. Then we tried to run his office, but ultimately it was not a very successful attempt to run his office, because his clientele were big ones. All industrial clients were there. And then at 99, Bihar Jharkhand was a united state. They would not trust juniors because those were corporate clients, and then they said that we'll hire the biggest who's available. So 2000.
So you could not make use of the existing clients.
So we were just beginners. As it is, people would not trust us. So, but I still remember one person. He was an HR head. Call it prescience of his or whatever. Usha Martin was a company in Jharkhand. That day when he came to our office, he told me that one day you will become a big lawyer. I can't hand over the case to you, but I know, I have seen you work, but someday you will make it big in this profession. I don't know why he said that, because I had very little interaction with him. And
must have seen something in you.
I don't know what he saw, but then he was an old man, and he was the HR head of Usha Martin. I still remember.
But that stayed with you.
That stayed with me. That was 99 now, going to be almost 30 years. I still don't remember his name. Probably if I would meet him, I would definitely thank him. And then one other person who ever told me that you are different from others was Justice Jyotisharan.
Okay.
So, I had gone with Pawan Kumar to Ranchi to assist him in one of the cases. So that was the first time I met him there in Ranchi. He was with Mr. Y.V. Giri. And two of them were good friends, Y.V. Giri and Pawan Kumar. They were there in the office. They were there in the hotel room. And me as his junior and Jyotisharan as his junior of Mr. Y.V. Giri, we came out. We were there in the garden. And said ki he would call me by my home name. We were introduced as with my home, because my senior never knew my official name ever. So he always addressed me with my pet name or the home name.
What is it?
Yogi.
Yogi.
So he said he would always call me Yogi. Justice Jyotisharan would always call me Yogi only. So he said, Yogi, I don't know. There has to be something different in you, because I have never seen Pawan Kumar bring any of his juniors to assist him ever to Ranchi, because he is a very good judge of human being. There has to be something different in you that brought you, that was why he has brought you here. I don't know what is it, but then you will make it someday. He told me that day. And there I was 99. I had still not become a lawyer by then. I was still only working with him. And those were two. But then just had to happen. 2000, we couldn't run his office. It was a complete failure. And in fact, it was a disaster. So we opened up our own office in the garage that I had.
Until this point of time, you quit already?
No, I had not quit. After we failed it to run Mr. Pawan Kumar's office.
Oh, so this was before SIS security?
Then, because 99, once he died, we thought that we'll continue, but then we found it very difficult. I at least found it, because I had no background in law, and I had no background in Patna. I had no background deep into the districts. So I saw people getting briefs from different districts and all. So I realized that by then I had given out my biodata to at least 100 people or 500 people. But it did not materialize.
So 500 printouts.
So I lost about 500 pages, and it was not even worth the number of pages that I expended and the money that I expended on those. Then I realized this is not the kind of profession that I want to work, because I can't get clients. So it's better to join something where there is a definite source of income. So with my background, I made an application to SI. I saw it in the newspaper and then made an application. So I went for an interview, and then I was selected also, and I joined. They were paying a handsome salary of about 10,000 rupees then. And at that particular point of time, we are not even earning 10 farthing also. So it was a grand sum for me. And I realized that this is the job that I want. I went and worked there for a while. But then again, as things would have it, I didn't like that. I quit that, again came back. And then continued. And
why did you not like the job?
There was something about it that I don't like hierarchy. I am not subservient to orders being given to me, in spite of the fact that I had worked in the army. People in the army would tell me that I am a civilian, and when I came out, people would tell me that you have that bent of mind of an army person. So they thought that I am a rebellious in army, because I would object to everything, because I would not take everything on the face value. So they thought that I am more akin to somebody who is from a civil background. So they thought that I'm a misfit in the army. When I came back here, they thought I'm a misfit here also.
In the civil society.
In the civil side also. So I didn't like I was destined not to be
Right,
into
right.
some kind of a job. And somebody, sometime way back when
Do you think there's a part of personality because of which you had to quit that job because you do not like hierarchy, you think independently, you think critically, all of that?
because of that only, because I think that I can't work in a system where, irrespective of whatever is right or wrong, I have to follow.
Mm.
So that was not in me to follow all kinds of orders only for this reason that somebody has said something. So I always thought that it is everybody's authority is open to question.
When did you identify this trait in you? Was it post army or?
I don't know. In the army, people would tell me that I have this bent of mind. So I am not. I was a misfit in the army because there everything has to be obeyed.
Right.
Okay, if somebody tells you to do something, because I very distinctly remember one of those incidents, and we were there in Rajasthan, and we were in op duty, and then the officer in our CO, commanding officer, was there, and everybody was there, and then the GOC&C had come in. He flew in, and then we were all sitting there, and and then somehow he put a question to everybody. Do you think there is some problem, any problem that you all are facing? My CO also would not say anything. His 2IC would not say anything, but suddenly something in me told me to say something. And I said that, sir, there is an issue with regard to medicines. Everybody was shocked that nobody, including the CEO, was saying anything about any problem. And there is this small second lieutenant who's telling the GOC&C saying that there is this issue with regard to medicines and medical care. So, like, what is the problem? I said, we don't have the medicines and the supplies are irregular. And he said, "Well, achha. Yes, yes." He called out my CEO. Is it a problem that he's saying? He's saying, yes, yes, sir. So after he had left,
Was that acknowledged as a courage or audacity? How dare you?
I mean, it was labeled as an audacity, but my CEO was very supportive. My CEO was very supportive. So he was also surprised. He was a Sikh guy, but he liked me for that reason only, because I could question people. I could ask them questions even in worst of the times. In the best of the times, I could question them, and I would not take people's word on the face value.
So you're already a lawyer before you became a lawyer.
Could be somebody even told me that you are good in splitting words. So you should join the profession of law. That was my father's friend. Hair splitting is what people call it. Otherwise,
So moving forward, you quit your job here and then you again start practice.
I started practicing.
Now this time in district court.
No, initially yes. I was shuttling between the district court and this place, and because then we realized, me and my friend who's now in the hospital. So basically, we realized that this is not the place that we are going to get any briefs and all. It's a difficult place to get briefs. So we decided to go to civil court, Patna Civil Court. And I also had a friend of mine, Alok Singh. So we together decided that we'll go to Silstax also. So Silstax office and all.
It was you, Mr. Alok, and one more person, no?
Vinay Mistry. Vinay Mistry.
Vinay Mistry. So his father made your first office.
Yes. And he made that office of
I really
ours.
liked his story as well.
Because he was somebody who could not write or read English, and then he would come to us to get it all corrected, and he had done his law. He was basically a munshi to the father of my senior, Pawan Kumar. So he did law, and then he became a lawyer, and then he would come to us saying कि इसको correct कर दीजिए. So we would tell him that कि ऐसा करते हैं विनय जी, इसको करेक्ट करना तो आसान नहीं है, पर हम लोग अपने से लिखा देते हैं आपको, ठीक है. एंड दैट वाज अबाउट 30 years back, and now he can write, and he writes SLP as well, and you
SLP
can't
before
make
Supreme
corrections
Court.
you can't make corrections to that now, because within that limited range of his, he knows what to write, and he has absorbed everything that was told to him over a period of time, that my limitations is English, so I have to confine myself to these very words, and to express myself I have to use only these very words. Within those confines of those limited vocabulary of his, now he writes SLPs and you can't put a pen to it. And that is the most
That is the
interesting.
beauty of this profession. It
Yes.
gives you so much room to learn.
Yes,
And
so much.
irrespective of wherever you come from, you can always pick up.
And I personally believe means I believe only after all these years that I have spent, that this is one profession, and in fact not about this profession but any profession. Any profession would mean either being an engineer or a doctor or a lawyer or chartered accountant or a CS. Merit counts. Merit counts, because over a period of time, if you have merit, it will reflect somewhere over a period of time in your practice.
Right.
So if he has made it this far, he has bought a land for himself, he has constructed a 4-storied house for himself with that limited range of his
He is
words.
based in Patna.
Very much. He's here, not very far off from this place.
Someday
also.
I'll talk to him.
It is Lekhanagar,
Okay.
not very far off from this place, maybe about 2 kilometers from here.
So share your experiences from the district court when you started.
That was financially very challenging period for me. And times were very desperate also, in the sense that we were not earning anything, and then I had got married, and within a year or two I had a son also. So that period between 2001 and 2005 and onwards, about till 2006, 7, 8, that was very financially challenging. Means there were times when one was desperate for money and all. But then it just passed over, as bad times do as they do. They also pass. Those were the cloudy days. They came and they went, and then the best part of it was the civil court practice, and we learnt a lot. Me and Vinay Mistry and me and Alok Singh. Me and Alok Singh going to sales tax office, me and Vinayji going to civil court. And I'm really grateful to his father who gave us that office. And the only promise that he extracted from me was that I will not leave his son ever.
He has shown confidence in you.
So we're still together.
Right.
So that was one promise that he extracted, and we continue to fulfill that promise. And
so from district court, when did you move to High Court?
No, it was not something that I actually moved to the High Court. It was something like we continued to work in civil court, we continued to work and come to the High Court. In High Court, basically what we were doing was others' work, or work which were supposed to be out of gratis. Maybe some relation of ours, a friend of ours would ask us to do some case. So we would do those kind of cases basically. So we were not ever paid for it. But that was an opportunity for us to, and you had to take those opportunities with both your hands. And since we didn't have too much of work, so we had enough time to research on those cases. So we did get a few of cases which were quite complex in nature, and we were able to win those cases. We means the petitioner side.
Mm-hmm.
There were batch of cases, and because my argument mattered, so that at that very threshold, that is, if you would read those judgments, that is of 2001 only.
Electricity matter.
Electricity matter and industrial policy matter, Keshav Sheetgre. So that brought certain recognition, and because of that peer review that you call in every profession, so that got me into a position where I started becoming visible in the High Court. There were lawyers who were opposing me. They realized that he's a good stuff.
He has got merit.
He has some merits. So, I mean, and it didn't change anything overnight. The clients don't start coming to you because you have won a case.
Right.
For that, you need a different kind of skill for clients to come. So we got them, but then people took advantage of those, and then there were a whole lot of cases that were filed, and people got relief on the basis of that case. But people would, every time that people would read, they would know he had argued. So everybody who read that judgment to get a relief for themselves, they knew that so they would approach me for any kind of suggestion, not for the purpose of engaging me, but for any kind of suggestion. So, and then a few PILs and all, which my maternal uncle had filed. A friend of mine who had another cold storage, he had an electricity issue, so he gave me that.
Started getting analogous matter related to.
No, not analogous. Not even one single matter I got relating to that.
They were seeking opinion.
They were only asking that this is what you have argued. This is what my case is. So,
what can be done?
What can be done? So, we had to, since we are doing everything gratis, so advisors were also gratis. So, and we are not in a position to command any kind of a fee from anybody. So we just starters. But over a period of time, judges started recognizing that he's also a lawyer. That a lawyer by the name of Mrigank Mauli also exists in this High Court. That took time. And then suddenly in 2005, Mr. Ashok Jain was leaving this place. He was to join a job somewhere in Gujarat, and those were cases that he was doing for a trust, and that trust offered him a job, and on a very handsome salary. So he decided to leave Patna and join that place. So he was looking for a lawyer. So he consulted a few of them, probably Justice Navniti Prasad Singh. He said that you can ask him in case if you have the confidence to leave your briefs with him. So he said that he called me to his office. So I went to his office. I had never met him before that. So he said that I am leaving this place and I want you to take over my briefs. And that was for somebody like me who was just crawling in the profession and being asked to take over a certain number of briefs from somebody and a successful lawyer. So
Must
for
be
me, it was a big ask. Means to handle those briefs, to handle those clients, because for me, I had no experience in handling clients. I was only doing people who had done all kind of dirty work in their own office and brought the brief to me. So I had no interaction with any of the clients. A civil court, yes, because civil court is a different ballgame altogether. You get money for everything that you do, 10 rupees, 12 rupees.
Small amount.
Small amount.
But in High Court, what happens? You get a big amount, otherwise you don't get it at all.
There you get every day. Okay. Here you get once.
Okay.
till the time that you actually become a senior and you have a corporate office engaging you.
Then you
Even
start getting for appearance.
for appearance, even only in cases where there are big companies. Even otherwise, people try and negotiate a one-time fee for you. See, you quoted, there'll be a bargain, and then there's a one-time fee. Even corporates also. But big companies, they definitely pay you for but that is only for seniors. And at that particular point of time, the only place that you got some money every day was civil court.
Civil court.
So 12 rupees was what was being charged. So we would also get some money. Me and Vinayji. So our target was about 150 rupees, and then we raised it to 100 and then 150. Over a period of time, we thought that now we are getting 50 rupees every day. So we'd share the amount, and then we raised it to 100 rupees, then 150 rupees. Probably, so it all progressed over a period, and then over a period of time, we were simultaneously working in the High Court. After the brief came, that phase was really challenging. Means in the sense that one always would think that this is not a profession to be in, and then you didn't know anything else to do. See, because you were stuck somehow. You couldn't go and do a job because your
against hierarchy.
Because your mind setup was like that you will not accept somebody sitting on top of you, and then you can't go and work outside. You can't. You're not getting enough here also, and those were really trying time. But then over a period of time, slowly, I could over a period of time, I could actually retain those clients.
However, they were coming to you.
They continued because they continued to come only because one could get them relief. So they could get relief, so they would recommend to others, and then it multiplies. It has a cascading effect kind of a thing. So just happened. वो कहते हैं ना कि चलते चलते फिर कारवा बन गया, तो कारवा बन गया.
But to sum up your journey, you are a first generation lawyer. Your professional life has been full with ups and downs. You have joined army, quit army, prepared for civil services, couldn't join, started practice, again joined a job, then left to start again. Then you identify yourself as an introvert who cannot do a lot of things to get clients, but you still stayed in the profession, doing really good for yourself. So what are the few points that really helped you? Like, how do you want to sum up your journey? One which you just said, that there's a cascading effect. You do one work, you get a relief for your client, they recommend other people to you.
Because initially when I had joined the profession, then I realized that the only place that you get your briefs from is either if you know certain set of people, either here in Patna or somebody out in the district. So those lawyers would recommend and they will send you the briefs and all. But over a period of time, I realized that this peer review is something very, very important aspect that people have actually missed out. In my career, I think there was this destiny. And I am really grateful to him with capital H, who actually finger led me all my life. If I look back, my journey has not been linear in kind. So if you see the lines that go left, right, center, I mean, they are not straight. So I have gone left, I have gone right, I have tried this, I have tried that, and then I am ever grateful to him. And yes, how do I sum up my journey? Perseverance matters.
Perseverance matters.
Yes. And if you have merit, this profession, and you have to have luck.
Luck is there.
Luck is absolutely, because anything that you do, 99% is perspiration, and that 1% is that people call it
Right,
differently, but I call it luck. You have to have that 1% luck, right?
And that is not in your hand, no? What is there in your hand is that you stick to something. You do
that
not quit.
perseverance, perspiration is part of you, and that one is what that H, capital H, has decided for you, and that matters, because how do you define it in law terms? Where your case, because I've always believed, and over a period of time now, that my that faith in that thing has become so reinforced that it's a punter's game. High Court is totally punter's game. Where you will land up, that is your luck. You throw the roulette, and where it will, you move the roulette, and where it will stop, you don't know. Because ultimately, where the case lands up, whether he's a positive judge, whether he's a negative judge, whether he's pro-government, whether it is against government, all these constellation of factors would matter, and the ultimate credit goes to the lawyer. But in fact,
there's so much luck
that is not your luck. Maybe it is the luck of the client. That has, we always tell people that good cases get dismissed and bad cases get allowed only because of this. That
who is before the bench?
Which is the bench?
Which is the bench?
And what are his thought process, and what are his background, and where he comes from, and what kind of practice he has done, and what kind of briefs he has held. So it all depends upon his experience of life and the luck of the client, and those constantly, and then that adds up to your luck. And that growth of yours and that luck of theirs, and the presence of a judge who is inclined, maybe that 1% is all that constellation of factors. So if you have got a relief, not because you have perspired for that 99%, but only because that 1% is their luck. We got into one court where and those cases were taken up by that judge, either out of turn or in the course also. Those are all luck.
So is there anything called pro-people, pro-government, or pro-justice? Like, what I mean to ask is that in a case, one cannot just say that an individual has to be pro-government or pro-people. An individual has to be pro-just. Like, the judge should uphold what is just and not what is good for the government or for the people. What is your view on that?
See, it's about perspective, where you are looking from. There is no absolute definition of justice.
No, there is not. There is not.
Everybody will have to agree that somebody may think differently about justice and somebody else. But there are certain things which you cannot justify by saying that this is justice. It defies justice. The very concept of justice will be defied. Like the basic example that people give, भाई रोटी तो चुराया है, वो चाहे एक रोटी चुराया हो, चाहे 1 करोड़ चुराया हो, है तो ऑफेंस चोरी का है. So that was in general parlance that common parlance people give examples of. But having practiced on this side, having seen what actually happens in the courtrooms, there are times that you feel that things are really unjust. That would again depend upon how the judge is thinking about a certain set of facts. See, especially in criminal law, which I personally believe has completely failed. Criminal jurisprudence is a complete disaster in this country. 2 people can stand up and tell that he is murdered and then he gets convicted. This is not the kind of justice that we are looking for. There is no forensic investigation. There is no scientific investigation of any of the offenses. You just have to get two people to say that he has done something, and then he gets convicted either for life, only because somebody has said so. So criminal jurisprudence is a complete disaster. So we were talking about justice. That is not justice. Then we were doing a certain cases where people had not got compensation for land, even when the government had taken over the land, and that was in the year 2000, and we were here in the year 2017-18. Now, what was the issue? The delay in raising an objection. Now, in 18 years, about over, you must have heard about the Ordinance Factory in Nalanda. You can imagine hundreds and thousands of farmers had not been given compensation, even as of today. Why? Because in the year 1901, the British government had decided, they had carried out a survey, and sometime which is known as cadastral survey, and then in the year 1901 they found that a certain piece of land was jungle, गैर मजरूआ आम, गैर मजरूआ खास, गैर मजरूआ झाड़ झंकार. Those are the kinds of label that was given in that. We are talking about 1901. Zamindari. It got settled over a period of time. Now the government says, as of today, that I will accept only the 1901 cadastral survey, because thereafter there has been no survey. So if that entry in your Khatian says that it is Gair Major Jhad Jankar, then I'll treat it as a forest land. So this belongs to me. And the court tells you, go and file a suit for it.
Civil suit.
If you tell that farmer whose land has been taken over, whose land has gone into acquisition, you have laid out a road on it, you have laid out a factory on top of his land, and you tell him you cannot agitate because you came late. Late by how many days? About 1 month late, 10 days late. I can't condone the delay. Can it be said to be justice? You have taken his land, you have taken his livelihood, you have taken away his house also. So that is not justice. By any sense, from whichever perspective that you see, you can't say that this is justice if you are in your rightful mind. See, law is about common sense. It is for the judges to interpret. Now it all depends upon the judges, what kind of bent of mind they have. Is it pro-government or is it anti-government? You don't have to be anti-government in this. You have to be pro-justice.
That is what I asked.
Here you had to be, you could have, because those are words only, na?
Right.
And each word is pregnant with meaning. So you could have interpreted. You can't say, you throw up your hand saying that law is like this. You can always interpret the law
in the justful manner.
And people have been doing it. Laws have got changed because you say the constitution is a living
document.
book. So if it is a living book, it changes its meaning over a period of time depending upon the context. Why can't the other laws change?
And because of technicalities, nobody should suffer.
Nobody should suffer.
Or because of omission of government.
They have been thrown out of the land. And we lost that case because the impression that was conveyed to the judge was that the central government would be losing about thousands of crores. How can money matter in these things? In somebody, you are taking away somebody's hearth and you are taking away his land, and then you say that it can be compensated because the government will have to shell out so much of money. So they should not be allowed to get compensation because they have come late. And late by how many days? fine. The law says that you can't come. But even the Supreme Court has condoned 19 years, 20 years of delay in land acquisition matters.
From cases to case.
Case to case. And unfortunately for that case went to the Supreme Court, it was dismissed in limine. If you become a judge, the requirement is that you have to have empathy, because you're not feeling for those people.
Does this matter where the judge comes from? Like if a judge who has been a lawyer on a state panel, that individual will always be pro-government?
Not exactly. We have seen judges who have actually turned out to be real good judges, in spite of the fact that they have always been on the state side. But yes, you will find there are things that are not okay. They are not okay. They are not okay in the sense that if you stay on the government side over a period of time, you are fed with certain kind of a narrative. And if you tell somebody even a lie over a period of time, then they start believing in it. And once they get to a position where they have to decide, now at that particular point of time, they have this tendency to disbelieve people who come against that set of people with whom, in whose narrative you have been believing all through. So you have judges, a set of judges who may not have practiced on the petitioner's side. They may not feel for them. They may not know the ground realities, because every time that you interact with a client, you are not interacting with a client but a set of people. There may be a possibility that only one person comes, but he actually is narrating a set of facts which is so much evident from the fact that what he is trying to narrate to you is basically a reflection of the society from which he comes from. So once you are interacting with that person, you are basically interacting with a part of the society. So every time, if you are a practitioner on the private side, you are not only trying to interact with one individual but a part of the society, and you come to know of the ground realities. So if you have to deliver justice, you have to be aware of the ground realities. But then that could corrupt your way of thinking as well. That may not be in consonance with law also. Because law is not something, because I personally believe that what you get in the High Court is basically a set of documents that is delivered by a judge. You can take it as justice in your favor, you can take it as injustice to you, whatever, because this is not a place where you get justice, you only get orders. See, my personal is, आपको फैसला मिलता है, न्याय के उम्मीद में मत आइए, और दूसरा ये जुआ है, खेल डालिए, किस्मत है तो जीत जाइएगा, किस्मत है तो हार जाइएगा, कुछ पता नहीं.
Nobody could predict.
You just can't predict what kind of lawyers that you get, what kind of judge that you get, what is the thought process, what is his background. It is all luck. So खेल डालिए, देखा जाएगा, जुआ है. So that is why Supreme Court says it's a punter's game. If they say that if every other court passes a different order, then it becomes a punter's game. In fact, it already is. I mean, it is not only true for High Court, but it is true as well for the Supreme Court. If you go to the Supreme Court to talk to the lawyers, they will definitely predict the outcome of a case by simply telling you where the roster will take your case to. See, this is the roster of his. Your case will be going to him, and this is what your fate will be. And that is exactly what happens. So basically, it's punter's game also in the Supreme Court.
But then what about doctrine of precedent, which says that there has to be some uniformity in the judgments that the judges deliver? What about all those theories?
It's a joke. Okay, doctrine of precedence is a joke now. That is what my personal feeling is. Because as of today, the Supreme Court, when it passes an order on anything, it never says that this is the definite thing. It is always open to, subject to context, subject to the facts of the case, subject to this. So it is always open to a
There's a
judge
lot
to
of room for
interpret.
interpretation.
See, how do judges distinguish the judgment? The facts are not similar. See, if you don't want to agree with the Supreme Court's judgment, you can say the facts are not the same. The fact situation is not the same. The law that has been applied, or you can ignore the judgment altogether. That is a complete dishonesty. So that is what I believe, that it is a complete, you ignore the judgment, or you pick up one paragraph from that judgment out of context and say the Supreme Court has said otherwise than how the petitioner's counsel is interpreting. ठीक है. So it is never in a definite sense that you can all, because you have judgment, because I still remember Siddhar Shankar Ray. He had come to this place once, and we were sitting in his, we had gone to brief him in Moria, and then he told that today, if you want to find a judgment of the Supreme Court, तो गाय पे भी जजमेंट मिल जाएगा आपको, ठीक है, घास पे भी जजमेंट मिल जाएगा आपको, ठीक है. इसलिए you want to find a judgment in your favor, you will get a judgment. You want to find a judgment against yourself, you will find a judgment. It is now open to the judge who's sitting there. What bent of mind he has, what he wants to do with that case. He will rely on this judgment, he could rely on that judgment. Because none of those judgments are in definite terms.
Talking about dishonesty, we were talking about earlier that how in the judgments, judges are not recording the arguments that were submitted by the respective lawyers.
It happens, and you don't give credit to the lawyers for what they have argued. Even when they file the written submissions, you don't record those judgments. Even when you are sitting there, you don't record anything you don't pen down his submissions, and then you don't record whatever he has said, and you pass on the judgment on the basis of something, and then again you rely upon a judgment which was not cited by either of them, and it was something that was in your know, and the parties were not in the know of it. And sitting back in the courtroom, sitting back in your chamber, you rely upon a judgment, and then you pass an order, either against or for the petitioner. That is again not fair.
So the points of the judgment were never, the lawyers were not privy to the points of the judgment.
Yes, lawyers were not, they could have, even the state could have been benefited by whatever has been said in that judgment. The petitioner's lawyer would have been benefited, but you then rely upon it in the rooms or in the chambers that when you sit down there and dictate orders, you rely upon a judgment saying that neither of the persons have cited this, and then on the basis of this is what the judgment of the Supreme Court says. You pass an order. Again, this is not fair.
And the difficulty, what's the difficulty if your submissions are not recorded? So when it goes for appeal,
what if it is not recorded? Then what happens is that if you go in for an appeal, the Supreme Court says that the judgment is a fair recording of whatever has been argued in the court. If you have not recorded, then you should go and file a review. And that is both, one, embarrassing for the judge, the second, embarrassing for the lawyer to tell the judge, saying that, so people prefer not to go in for a review. They prefer an LPA or an SLP, saying that these were our issues that had not been recorded by the court. The Supreme Court may even tell you that go and file a review application, and it is open to the Supreme Court to entertain that also. But that is very, very, very unfair on the part of a judge, and I personally call it dishonesty on the part of the judge when they say they don't record your submission. And see, there were times when the Supreme Court would tell in its judgment that basically the judgments are an ode to the caliber of the lawyers. It is a reflection of what the argument has been made.
Right.
The better the argument is, the better the judgment comes out to be. And if you don't record, because then the judgments are as ordinary as any other judgment would be.
Right. The contents of the submission matters a lot. And after we discussed this with you, after I discussed this with you, this was so enlightening for me. So I could make more sense of what the news, what is happening in contemporary times. Like for example, recently you must have read the news in MP. I think Indore High Court has, was it Indore or? I think in Madhya Pradesh only, High Court has directed police officers to file an FIR against this MP who told Colonel Sophia that their own sister has delivered a talk on it. So what the state did, they did file an FIR, but they filed it in a language that will be cost at any point of time. Then the High Court has again brought them and highlighted this to them that this is not in and they actually argued that we have complied with your orders, that in your order you have only asked us to file an FIR and we did so. And this was the time I could make more sense of what I have discussed it with you, that the contents of FIR matters, because if it is not written in a way which the judge has directed or what the issue is, then it will be caused at the later stage.
That is true. That is true, because I don't know, matlab, it's very difficult now to expect judges to. You feel that you have been cheated in the sense that all your efforts have gone in vain. See, you prepare a case as a petitioner's counsel or a respondent's counsel. You prepare a case. So much of effort goes into it, and then you don't record it. What use is it? See, people are now saying that what use is in subscribing to books and all. When the judges are not interested in either going through those judgments or not even appreciating those judgments, it's not worth even buying books now. I don't know about other high courts. At least in Patna High Court, that is true. Means, there have been instances when no credit is given to the lawyer for whatever he said. You take a credit for whatever argument has been made. You don't say that he has made these arguments. You say that these were other issues that were involved in this which has not been argued. So you bring to the notice of the court that this is what the issue is about, and the court then claims a credit to himself, saying that none of the parties had actually argued and this is what I have found. Or even if they say that it comes in neutral terms, as if the court has actually delivered that kind of novel idea, which was actually argued by one of the counsels of the either side, and then the court in neutral terms, it doesn't gives credit for that idea to somebody, either of the parties, and then says that this was also an issue, as if they found out that as an issue, but when in fact it was argued by either of the sides.
How often does this happen? Is it a matter of practice in all the courts?
Especially means, see, if it is small cases, then it becomes very easy for the judges to, if it is complex case, if the facts are not very complicated and it doesn't involve a lot of law issues, so then it's very fine for the court to record submissions on the either side. If it becomes a constitutional issue, so where long list of judgments are referred to, and then a kind of argument is created based on those, now you find it difficult to deal with those arguments. You think it proper to ignore them. Now, I can't deal with those arguments. So, since no written submissions have been given, let's ignore them. Don't give credit to the lawyer who has argued. Basically, you are penalizing that lawyer for whatever reason that you may have. Don't give credit to him. Don't put it in somebody else's mouth. If there are a set of lawyers, don't give credit to him. Put it in somebody else's mouth. And they argued it. He didn't argue anything. You invisibilize that person in that entire judgment. So what is this? This is basically dishonesty for whatever reason. they choose to do it. This is how it is, but then
We can only hope that the practice gets rectified.
hopefully,
Yeah.
let's see.
I wanted
Think
to
so too.
discuss two cases that you have been part of. One is the case on caste census and the reservation subsequently, which was given in Bihar. You were lead counsel in that case. And what I wanted to discuss with you was the issue that you argued, I've gone through the judgment, was there were two terms which I found very interesting, very fascinating: adequate representation and proportional representation. So this was your argument.
Means
Can you highlight the difference? What is it?
what we were trying to emphasize was adequate is so far as scheduled caste and scheduled tribes are concerned. But so far as it is that, and that adequate, proportionate is scheduled caste, scheduled tribes, and adequate is so far as other OBCs are concerned, any other representation is concerned. So basically, what we were trying to emphasize was that if you say that it is there is a requirement to give an adequate representation, then you will have to have a certain set of data.
Again, the same problem which you were highlighting earlier, no, that after 1901 there has been no survey.
Survey is different. Survey is with regard to revenue. That survey is with regard to, but census is different.
Some form of data. Like
some form
what
of
happens
data.
with survey and
you have to have certain form of data.
Like in the criminal law also, what you discussed, that there's no forensic investigation. So what happens with these when technologies become part of investigation? There are expectation that the better outcome would come.
Better outcome would come. In theory, we may have so many things on paper saying that this is how you have to have a team of, the moment a crime happens, you have to have a team of forensic experts being on the site along with the police there. They have to take evidence, they have to take fingerprints. But is it actually happening? No, it isn't.
There's no forensic lab here.
I'll give you an example. We were doing a case, criminal trial with regard to in Jahanabad. It was a case of honor killing. See, the police comes to the site and then it finds that the entire house has been scrubbed, but all over, and there are cow dung plasters which freshly been done on the walls. And there is an evidence with regard to certain blood splashes around, and it is so much evident from the eye itself. And then that body is recovered at certain place. They say that that boy had come to watch what India-New Zealand match or India-West Indies match at night, and then he didn't come back. In the morning, complaint goes to the police comes, and then it finds that at that particular point of place where the TV is there and then others are there who sat through the night, and then they said that no, at such and such point of time he had gone back to his home. But actually, the police actually found, and it is part of the inquest report, saying that the place was scrubbed clean at certain places, and the walls had been fresh cow dung plaster had been done, but they could see blood stains around, and that body is found. And it was so easy to relate the murder of that person whose body had been found about 2 kilometers far off with the site of incident by taking the sample of the blood. But nothing was done. Everybody was involved. Whole lot of people had been involved as an accused. Whole lot of people had been accused. People had been made accused on either both the boy and the girl had been killed, and their bodies were found at different places, 2 different places. The family of the boy had lodged a case against the family of the girl, and the girl's family had lodged a case against the. And the place where the incident had actually taken place, it had all the marks of something had actually happened there and some murder had taken place, because blood stains were there. They could have taken that sample, related it with the boy and girl sample. It would have become very easy, but nothing was done. They all got acquitted. So, what is this? This is no scientific investigation.
Right.
And the SP was involved, DIG was involved, but nobody even bothered to get the entire thing done, because in spite of the fact that the manual says like this is how it has to be done, this is how it has to be, nothing happens.
True.
So there's no scientific investigation. So we were talking about adequate
caste.
and proportionate representation. So adequate is basically dependent upon data that you have to furnish to the courts, saying that we don't have an adequate, and the data which had actually been presented, and we had a certain set of experts who had actually, means credit to them, they had collated the entire set of data, and they did a humongous amount of effort had gone into collating those data and then getting the statistics and then coming to a certain set of conclusions, and a very authentic way of going through it. And they actually found that they had adequate representation, in the sense they had 64% reservation. So if the reservation was adequate, there was no reason for them to go to 65%. So that was the ground. And then what was more damaging was that certain set of castes that they actually said had to be included within those set of OBCs. In fact, the data showed that they were they had far more greater representation in all kinds of fields, including social, economic, land holding, services. So the court, actually, we were able to point out to the court that it is high time that it is not a case in which the data had to go, the reservation had to go up, but it is high time that those people who were actually taking away the benefits of the reservation, they should go out of that list now. And
instead of increasing, you must exclude as well.
You should exclude those people. Maybe if you exclude them, there will be no requirement for going
increasing
up. Yes. The problem with reservation, as Justice Gawai also said, and others, in that the sub-classification of scheduled caste, which is that came from Punjab. They said the people who get into the general compartment now, they don't want others to get into it. It is that kind of a story now. People who have actually been benefited by that. In fact, if you see the Rohini Commission's report, Rohini Commission's report says that over 2,900 castes are included in the OBC list, but almost 30 to 40% of the reservation has been taken away by 10 or 12 castes. So, but politically, it is a very sensitive issue, that if you exclude them, then where do you get your votes from? Or maybe they are more influential so far as the OBC votes are concerned. So nobody, because Supreme Court has already said that you can make a sub-classification. Now it is open to the state government or the central government to make that sub-class. But which of those states are doing it? Only those states which have already done it, they are doing it. But for others who are new to this kind of sub-classification, they don't dare to. Because there are so many powerful castes who will have to be excluded from the entire thing. Let's see. It's something, there's a work in progress. Maybe someday.
Yeah, maybe someday. The another case which I wanted to discuss with you, a very recent case. I read it on the High Court's website. It comes from Muzaffarpur. What I found interesting about this case was because it was related to securities laws. I have masters in securities laws and I worked in an exchange for 2 years. So this was a quashing of FIR matter from Muzaffarpur, that angel broking.
Acha, Dinesh Thakkar.
Yeah.
Dinesh Thakkar.
Dinesh Thakkar. Very recent case. So what was interesting for me to highlight is people do not exhaust their alternate remedy. They go and file a criminal case because civil remedy is hard to get. or maybe they don't know.
Yes.
Is it the case that they don't know, or because
no.
the criminal case can be expedited? What was
See,
the
thing is that I don't know. I am only talking about Bihar.
right
The easy way to get your money back is to file a criminal case. Now the problem is that if they are relying upon the judge to reject their bail application. The moment he gets a bail, the case is as good as finished.
Right.
They're relying upon the judges to ensure that your money comes back to you. But this was one case in which Dinesh Thakkar was one case in which somebody.
Dinesh Thakkar is MD and CEO of Angel Broking.
Yes, he is the chairman and not only of Angel One now, not Angel Broking, Angel One now, and there are other sister companies also. There are at least he heads almost 6-7 companies now. So then it was 2012. This time this is 2024. Even after 12, because that was a case in which he was into commodities trading.
Commodities trading.
So he lost on. Means basically he was betting on copper.
Right.
So he lost on that bets, and those bets resulted into huge losses. Means they almost eroded the entire capital value that he had put in. So now he wanted it back. So the easiest way was for like people who have some kind of trouble with their vehicles, they file a case against the chairman of the Tata Group. See,
so it's a common practice here.
It's a very, very, very common practice.
What was shocking for me is, okay, in this case, police did not file the FIR. So this complainant, he went to judicial magistrate under 156(3) and under affidavit, and I think he has forced some signature as well. And under affidavit, after judicial magistrate given the instruction, the FIR was lodged. So it's not that the complainant was unaware of the law, the judicial magistrate was also unaware of it.
In fact, this was the second round of litigation. The first time that he filed a complaint was in the year 2012 with the same set of facts. But once Dinesh Thakkar case got quashed in 2016, then he decided to abandon that case. There were others also who were involved in that case, and ultimately the trial court acquitted them because nobody appeared on behalf of the complainant. Then after the acquittal, he filed another case with regard to same incident. The nature of the case was the same and the transaction was the same, that he lost on certain bets that he made with regard
to... He desperately wanted his money back.
He wanted, I don't know, he just wants to harass somebody, because had it been a case in which he actually wanted the money, he would have pursued the criminal case. But he abandoned that case.
He wasn't appearing either.
He was not appearing there.
But cost was imposed on him.
This time, first time. The last time, the notices were sent to him. He had received the notice. He did not appear here in the High Court also, and then he did not appear in the complaint that he had filed also. So after the initial deposition that he had given, or solemn affirmation that he had said, whatever that he had to say, and thereafter he abandoned that case. And while that case was still pending, he instituted this case. And after institution of this case, that the original case that he had filed in the year 2012 was disposed of with acquittal in the favor of the accused, and this case was freshly initiated. And then we came to know of that, and then we again filed a quashing application. It has again been, maybe next time he will again file another case. You don't know.
But in this case, I mean, okay, complainant, he has to harass whatever he has to do, but the institution also supports these people. Like the judicial magistrate should never have taken cognizance under 156(3), because in the petition itself, in the judgment itself, it has been recorded that SEBI is the rightful authority where you have to do, at all you have to have any recourse.
It is for the judicial magistrate to have applied its mind.
Right, that's what I
And maybe there was not even the full disclosure on the part of the complainant. Because had he disclosed all the facts, because he had not disclosed, because the document that had been annexed at the time of filing that application for 156(3) were not the documents that had actually been presented before the police. the set of documents were totally different. This time, because had he placed those documents with regard to the transaction of the year 2012, the court would have definitely asked him as to why have you instituted a case in the year 2021-22 for an incident that had happened in the year 2011-12.
Right.
But those documents were then not there on record. And there is no reference also with regard to the dates in the complaint that he has filed. So he had acted smart, and the court also missed out. It didn't ask many questions from him. It didn't even ask any question. In fact, it got it referred to the police. So an FIR was instituted. So
Yeah,
it happens. I mean, it's an everyday affair. in
maybe he
Bihar.
would have learned his lesson
No,
because
nobody
cost
learns.
has been imposed.
No, nobody learns the lesson. That should have gone out as a message to everybody, but it doesn't happen, because every time Tata people, if you Mahindra people, if they have some problem with the company, they make Anand Mahindra as party. Then if L&T is involved, then Mr. Nayak is made a party. If Tata Motors is involved, or any group of the Tata is, then N. Chandran is involved, and either or the one whom they would never even get an opportunity to even have an eye contact with them. Those are the people with whom they say that I had written to him, he did not respond, so he is also an accused. So this is how the criminal system proceeds, and the court takes cognizance. It is everyday affair. So the
Court
fault
shouldn't do
doesn't
that.
lie on the part of the complainant. The fault lies on the part of the judge.
True.
You make an issue out of any statement made anywhere in the country by filing a complaint here.
True.
So fault is not with the person who's actually making it. The fault is with the judge who's actually taking cognizance of that incident.
That is what I wanted to ask.
I mean,
That was very apparent for me after reading this.
because it is not his fault that he actually made, because he has an interest. But what interest does the judge has?
Right.
Salman Khan makes there's lawyer, very well-known lawyer in Muzaffarpur.
I
Yes.
know.
So, if for anything that happens in Bombay, he will file he made a statement there, he will file. And it is happening every day now, political cases also. You make a statement here in Nagaland, people will file a complaint case against you, and people take cognizance. Supreme Court will say, no, what can I do? Go and face, depending upon which court you get.
Interesting. So towards the end of the podcast, we have a segment where I ask a question from our previous guest, that if he had to ask any question from their colleague, what question that would be. And similarly with you also, I'm going to ask. So in the last episode, we had Mr. Ashish Giri, and he wrote this question that if you were to highlight your greatest contribution in this profession, what that would be?
Mentoring juniors, that is all. See, nobody contributes too much to an institution. And in fact, let me tell you very frankly, this institution never considers lawyers as part of that institution. See,
Isn't the institution run both by the bar and the bench?
the judges never consider lawyers as part of the institution. So that is a fact. At least in Patna, that is a fact, because in any decision that they make with regard to anything in the High Court that may affect the lawyers as well, they don't ask the lawyers as to what their opinion would be. So it is basically they own the institution, they own the judge, the High Court. Even if they are there for 5 years, 7 years, they own the High Court. So the judges, the lawyers were never involved in either in the centenary celebration. So it was of the institution. The lawyers are as much part of the institution. But in any of the decisions that they made, the lawyers were never made part. Or even as of everyday affair where the interests of the lawyers are going to get affected, we being part of the institution, we want to be part of the institution, but the judges don't want the lawyers to be part of the institution. They want this institution to be theirs, and they want to decide as to what is to be done with this institution. So basically, our contribution is only not to the institution, because it is owned by the judges, but to the lawyers as friends, and because I owe a lot to the
people.
bar.
Bar.
Personally, I owe, because I never had any background. If I am here, it is only because of the lawyers.
That is why you
Ha.
focus on mentoring juniors.
I don't have that much of time now to mentor, but then the first initial stages when I had that opportunity, I could do it. But then,
Because the kind of narrative which is there in the market, once I was told in Delhi by a lawyer that why would a lawyer mentor somebody else, knowing that somebody else is going to compete with him when he comes and becomes part of the profession.
see, there are two kinds of people in this world. People, like, I'll tell you what, like, people who have undergone ragging, there'll be two sets of people who will come out of that. People who would, because they have been through that toxic kind of an atmosphere, they would themselves turn toxic, and then they would like to rag the juniors more than what they have themselves faced. And
Or
the
they would
second
want
set
to
of,
change.
yes, or they would want to change. So for any kind of situation, there will be two sets of people. People who think that, for me at least,
Right.
I think that it was destiny for me to be here and to come to this place and to this level also. And I was grateful to somebody. So I tell myself that it is not because of me that I am here. It is because of some sets of constellation of factors, stars, people who just came together and then brought me here. So why not get them also, help people who are down there, appreciate people who have done well, people who are against you. Because that is how I have come here. So
Right.
you will have to, because I personally believe that clients, irrespective of whatever effort that you make, it has been my story, so I believe in it. I may be wrong also, because I believe that do what you may, the clients will not come to you. If they have to come, they will come. And I believe that it is destiny. So people say that if you mentor your juniors, probably they will take away your brief. Then it is destiny.
That's a good
So
way of
it has to happen, it has to happen. That is all.
Right.
Right. So if the destiny, his destiny says that he is supposed to get his brief from his senior's brief, he will get it.
Right.
So if my destiny says that I have to be helped by people around me, that is my destiny.
Right.
So he comes with his own set of lucks
Very
and his
interesting.
own sets of constellation of factors and whatever.
True.
So my contribution basically is only to that limited extent. I can't claim to have contributed too much to the High Court. No, nothing.
That's a huge contribution, mentoring younger generation.
Because
believe that's a
we
huge
still believe in being part of the institution, irrespective of whether the judges believe that we are part of it or not. They may lecture us from sitting there on the pulpit, saying that this is what you should do, this is what you. They may not have done it themselves, but because they have a right now sitting there to tell you everything, whatever they want to. But they may not have done it themselves, because there are quite a few of the judges whose juniors have not done it well at all, and yet they will lecture you sitting there about what you should do about your juniors, and this is what they did about their juniors, and none of them have done well for themselves. They are just carrying on. Okay, fine. You have a right. You're sitting there.
Thank you very much. I
Okay.
mean, it has been an enlightening experience talking to you. I would have never have learned all of this from books or from anywhere
No,
else.
any
So
lawyer would tell you all this. Any lawyer would tell you all
I'm
this.
glad that it has come. Everything has come from you. Thank you for your time.
Thank you so much. Thank you.
If you have enjoyed listening to this conversation, please consider supporting us for more such interviews. Thank you.